right. Well, I guess we'll let some people trickle in and we'll get started now. My name's Seth Bloom, and I'm the Senior Director of Attorney Services at LevelSet here in New Orleans, Louisiana. We also have a big presence in Texas and an Austin office. So doing our first CLE in Texas is very important to us. And we've chosen one of our stars as far as a participating lawyer in the construction field, and that's Ben House from House, Perrone and House, located in the greater Houston area. So today, it'll be a CLE course, navigating construction liens on residential. So super excited to introduce Ben and look forward to everyone getting credit for CLEs out there. This is part of our new approach to providing education for attorneys within the LevelSet community. So Ben, have at it.
Thank you, Seth, very much. Thank you for having me on. Thank you for helping me with this process. This is my first time teaching CLE to everybody out there, so please bear with me. I've made a dry run. I think we're looking at about an hour. I'm going to try to shorten it up. I take a little bit of a different approach with CLE. I'm a South Texas grad, which means we're all about getting it done, you know, so I'm going to tell you the CLE, the angle I'm going to take is less about strict study of jurisprudence, more about, I want to help folks. This is really targeted to folks who don't do construction lien work day in and day out. I titled my presentation, Navigating Construction Liens on Residential Property. I should have called it Why You Don't Have a Constitutional Lien on Residential Property, because that's pretty accurate. I mean, you got to do it right. Companies like LevelSet, attorneys, that's why involvement from somebody who knows what they're doing is important, because the law, any lawyer can tell you this, especially construction lawyers can tell you, lien law in Texas is complicated. It's not a thing you can delve into with any amount of confidence unless you put some time and effort into it. So the point of my presentation today is to help a practitioner who may do contract law all the time to help you have a set of red flags that go off in your head when you see certain situations. That's what I've built this presentation around. So you don't have to look at my face anymore. I'm going to put my PowerPoint up here for most of the remainder of this. All right, Seth, just to double check, am you seeing a PowerPoint here?
I am. Looking good. Looking good.
Hey, okay. You just got to double check the Zoom every once in a while. All right. Navigating construction liens on residential property. All right, about your presenter. I'm going to let y'all read through this if you want to. Like I said, South Texas College of Law. I did AmJur contracts. I have a Bachelor's of Science in Construction Science from A&M, College of Architecture. Do have a pretty good verdict on liens. You know, back several years ago. Actually, I got that verdict on my birthday. That's my website at the bottom. Okay, so that's me. I do about half of my practice is purely construction. Other half is other real estate, commercial, contract litigation, that kind of thing. That's who I am. All right. Constitutional liens. Do I qualify? That's the first question you ask. And I'm going to back up a little bit here. Constitutional liens are one of those things where a builder comes into your office and always says, hey, well, you know what? I know I got a constitutional lien. You know, I know I've been working on this fella's house, and you know, I didn't send any of the notice letters. I didn't hire a lawyer. Okay, you know, but look, I did this work 3 months ago. He's not paying me. I get a constitutional lien, don't I? And a lot of lawyers, you know, can fall into the bear trap of, yeah, I think that's true, because generally what goes around is that constitutional liens are pretty automatic and pretty bulletproof. You use constitutional liens mostly when you have missed your deadlines to use statutory liens, the notice deadlines. I'm not going to talk too much about statutory liens in this presentation, But constitutional liens are called constitutional liens because they are in the Texas Constitution. So, okay, this is where your analysis begins. Does my client's work qualify for a constitutional lien under Article 16? Examining the meaning of mechanic, artisan, and materialman. Why do we have to examine these meanings? Because these are the three words used in the Constitution. After that happened, and there's like one line in Article 16, Section 37 of the Constitution that says mechanic, artisan, materialman working on a article or building gets a constitutional lien. Okay, great. What is a mechanic, artisan, and materialman? All right. I'm not going to, you notice I don't have the definitions in here. I thought about that. I decided against it. That's because the definitions of these are based out of common law. I'm not even going to read them off to you because there's a lot of cases. There's some key cases that will tell you generally what they are. But when somebody comes into your office, and it's usually an architect or an engineer, they come and they say, hey, do we have a constitutional lien? That's actually a very difficult question to answer because it's very fact-based. You have to determine if they fall into, first, one of these three categories: mechanic, artisan, materialman. There's a lot of language behind all three of these categories, but this is probably the broadest part of whether you get a constitutional lien protection. What that means to say is, what I mean to say by that is, as we'll go through, you'll see it gets skinnier and skinnier depending on what type of work was actually done, that kind of thing. Okay, and we can compare this with statutory lien qualifications. That I do provide you the definition of. It is, quote unquote, furnishes labor or materials for the construction or repair of an improvement to real property. That's in the Texas Government Code, which is in turn cited by the Texas Property Code. If you're starting to think that, wow, there's a lot of statutes that internally cite one another and the operations between the statutes and rules is fuzzy, you're figuring this out because it is, and they are. So Texas Property Code says if you're that, you are a, you get a lien under statutory liens. But if you want a statutory lien, of course, you got to send your notice letters in, and the notice letters got to be right, and they got to be sent certified mail, and they got to be sent to the right parties. They got to be issued timely. There's a lot of rigmarole there. It catches a lot of folks out, again, unless you use a service or an attorney or something like that. So as attorneys, we got to know what to tell our clients and when to tell them about that kind of thing. That's outside the scope of this presentation, though. Field of potential claimants under statutory lien rules is broader. Yes, it is, because it's a simpler, it's at least a simpler analysis. And with the constitutional lien, there's a lot more, because the language of the Constitution is so sparse, there's been a lot more, and frankly, some kind of old case law determining who is what, whether your engineers or architects fall into those categories. And like I said, it's a truly fact-based investigation. So for instance, an engineer comes to your office, architect comes to your office and says, I've drawn some drawings for a building. Okay, was the building built? When was it built? Were your drawings incorporated? Was another drawing incorporated? What was your drawing incorporated into? Okay, as I go through these slides, you're going to see why those questions are important, and there's a lot of them. And then after collecting all those facts, it's our duty as lawyers to figure out under the case law if they meet the kind of the stricter bottlenecky language of the Constitution. My rule of thumb, and you'll see why, I hope you'll see why this is the case. And this is my rule of thumb. I didn't pull this from anywhere other than me. If no work was performed on or materials utilized within the property, the building or article, concerned, that's for the lawyer, be concerned. If you're representing an architect or an engineer or a construction manager that has not actually physically done any work on one of these properties and hasn't been paid for some kind of intellectual work that they have done, be worried as far as constitutional liens go. My understanding of Statutory liens is they're a lot broader in that context. So feel safer about statutory, feel less safe about constitutional. But if your guy comes in and says, look, I'm the builder, I'm there, it's my crew, we're building on the property in question, okay, be less concerned there because you know your constitutional, at least this part of a constitutional lien has been met. Okay, my guy or gal did some work for homeowner, so we at least get a constitutional lien, right? That's what I started the presentation off with. I get one, right? Nah, we got to keep going. Got to keep going. Got to keep our analysis up. The next two, requirement of an article or building. Again, straight language from the Constitution. So you got to look at how it's been interpreted by the court since. Constitutional lien is only available for articles or buildings that have been made or repaired by the lien claimant. So something, remember my rule of thumb? Something has been done on this article or this building. If nothing has been done, if we're just talking about in theory kind of stuff, be concerned, at least about a constitutional lien. Articles is roughly equivalent to goods or chattels. So what does that mean? If I'm not working on the building specifically, if I'm working on something that went within the building, do I still get a constitutional lien? On a good or chattel? Yeah, you should, but we'll see a little later. There's some limitations to that. Okay. So A&M Operating Co. case. I'm going to back up a little bit. A&M Operating Co. Is a case out of the Eastern District Bankruptcy Courts from 1995. For whatever reason, a lot of the jurisprudence in this area is from the early 90s, early to mid 90s, 93, 95. There's a couple cases from 87 we're going to talk about, or there's one case from 87. We're going to talk about a pretty important case from 1957. It's a Texas Supreme Court case, which is the only reason I'm talking about it really. But this case, as bankruptcy courts do, this case gives a really good analysis of what has to be done to get yourself a constitutional lien. It makes sense that this stuff comes up in bankruptcy court because they're always trying to figure out who has claims against who and whether those claims are valid. And the federal courts, of course, are required to, by their rules, to submit long and detailed orders, and they do. They do a great job of it. We all know that. This is basically, I've kind of stated the basics of their order. And that is, okay, what do you got to do? Builder better have. I wanted to back up and tell you about the facts of the case. So this is a case about a supplier of nozzles, flanges, and stubs and other fittings that were incorporated into the debtor, it's bankruptcy court, right? High pressure vessels utilized to separate oil. So this is kind of an oil and gas, but it's a construction case nevertheless. And that party that supplied those nozzles and flanges that were incorporated into the end device and the end machine, say an article maybe, qualified the supplier as a materialman, quote unquote, for purposes of establishing the constitutional mechanics lien. This is going to be a little bit important a little bit later, but the supplier, so keep this in the back of your mind, supplier did not make the goods himself. Okay, the supplier was a company that had personnel that made the units or a subcontractor that made the units. So what A&M held in effect, in reality, was that constitutional lien applies to a final article to the extent the value of the material supplied became assimilated with the merchandise and therefore irretrievable. Okay, so assimilated, irretrievable. You're starting to figure out that if you did something or supplied something that became part of the end, either product or property, you're looking good. But let's go over kind of my subpoints that I pulled from this case. I thought these were important. Supplied goods and have constructed all or part of a building or article. Supplied goods and repair, that's kind of the easy one. Supplied goods and repaired a building or article, also kind of easy. Supplied unique goods to the project. Unique, just supplied to the project. Because they're unique, maybe they care, maybe this court cares a little bit less about whether they were actually put into the project. Furnished off-the-shelf goods that were intended to be incorporated into specific buildings or articles. So I kind of cite this line because off-the-shelf goods intended to be incorporated. Well, a lot of the Texas Supreme Court, or rather the constitutional jurisprudence for liens, says that you better have done something in or on the property. Well, this A&M operating court says furnished off-the-shelf goods that were intended to be incorporated. Maybe they weren't. I'm of the opinion, after reviewing the cases that I have, that I think I wouldn't feel safe, feel really confident in telling my client, hey, we got a really good shot at a constitutional lien, unless their off-the-shelf goods were in fact incorporated into the article. A&M takes a little bit of a looser stance. If you want to read the A&M opinion, it also hammers on some prior opinions. So they were trying to, at the time of this case in 1995, it's my opinion this court was trying to liberalize some of the requirements of the constitutional lien, because prior to this case, the Texas Supreme Court had read the requirements of constitutional liens to be, fairly strict, fairly adherent to the language of what the Constitution required. So, okay, my last bullet point is, seem unclear? I think you're right. Yeah, you can't be sure. So it's always an argument, but these are some good rules of thumb from this case, and some good weapons to cite if you're looking for a liberal case to support a constitutional lien on for maybe an equipment or material supplier. All right. Privity. This is kind of fun. Okay. So we're still talking about constitutional liens, of course, here. That's mostly what I'm talking about in this presentation. Privity. All right. What do I mean by that? This is really about sham contracts. Okay. A lot of us in regular litigation have heard of, sham businesses, sham. You usually hear the word sham in conjunction with like an alter ego type argument. Hey, this company isn't real, or what have you. And in this context, it's a little bit different. So we have section 53026. That's in the Texas Property Code, chapter 53. Used to alter statutory lien rights where owner and general contractor are inextricably intertwined. How does this come up? All right, this is I've had a couple cases dealing with this exact issue, and this is how it comes up. Usually two circumstances. All right, the first circumstance is you either have an individual kind of well-to-do person who's developing multiple properties at once, and that person has either filed an LLC or is just himself acting as a general contractor. The other situation you have is kind of larger companies, I hate to use examples specifically, but 24-hour fitness. My case had nothing to do with 24-hour fitness, but a company that builds fitness facilities all over the place. Well, oftentimes large companies like that will be their own, or attempt to be their own general contractor. They'll use an LLC or something to separate it, but really and fundamentally, it's the same group of people making the decisions as the general contractor. All right, why does any of this matter? Privity is why this matters. If you're not, and this is kind of one of those things that a lot of lawyers who've taken a parting shot at this area of law know. If you don't have a direct contractual relationship with the owner, you're out for constitutional lien. Okay? Well, so if the same owner is now the general contractor, that's just downshifted you. Uh-oh, I'm not a general contractor in privity with an owner. I'm in privity with the owner's pseudo agent, sham general contractor, and I'm now a subcontractor, and I don't have a constitutional lien anymore. Well, Texas legislature kind of saw this one coming. So they said, okay, well, here's the deal. If you can prove that the owner and the GC are inextricably intertwined, remember that language from attorney's fees in Texas? Yeah, that's how most of us are going to know that language. So just use here, kind of coincidentally, I guess. If you're inextricably intertwined, then you have an argument that to upshift yourself back from a subcontractor to a general contractor, you're back in the game with a constitutional lien. You don't have to rely on statutory lien that you probably blew the deadlines on. Sorry, general contractors, they do it all the time. And what's really important, why I cite Trinity Drywall Systems here, is 53026, that's the Texas Property Code. That's not in the Constitution. Well, Trinity Drywall says that this analysis might also save constitutional lien rights. Now, that's a Court of Appeals out of El Paso, right? But hey, look, it's got the magic words, petition denied. That means you're looking pretty good if you want to make a sham contract argument for the sake of recovering your constitutional lien rights. So this is a very useful tool. You can have a lot of money between your party. Your contractor can have a lot of money depending on whether and to what extent this argument can be used. A lot of lawyers don't even know this argument exists because it's kind of obscure. So I want to make sure that anybody watching does. All right, here's the title. Check out the title. Look at this. Constitutional liens. Self-executing. This is the other kind of thing that your client always comes in the office and tells you, well, that's self-executing. I didn't file anything. I don't need to file anything. Yeah, well, there's a lot of reasons you want to get something on file. I say yes, but only effective against innocent third parties if something is filed. Think notice. Okay, this line, I'm gonna be honest with everybody. I'm not really happy with that line. I think it should read, yes, but might only be effective against innocent third parties, because there's a lot of law on the books that says that whenever you get a lien on file, it can come in and beat out other liens, even deeds of trust, even mortgage liens on the property. Okay, well, you don't even want them to have the argument about saying, I didn't have any notice, I didn't know this thing existed. So get something on file. That's it. And it's pretty hard to, I'll get into this a little bit later, it's pretty hard to mess up the filing of a lien you don't even have to file. Okay, so just stick with your forms that are available in practice guides or straight out of the property code that are used for statutory liens. Put in the information you think is relevant to provide notice. Go from there. There are even some constitutional lien forms, of course, available. Okay. Prudent practitioners should get a lien affidavit on file. Sure, just talked about that. Okay, yeah, we're going to talk all about homesteads. Don't you worry. All right. Chinks in the armor. Chinks in the armor. Preferential lien status questionable as compared to statutory liens. So there's a whole slide dedicated to this. It's the McConnell case from 1957. And I'll get to that in detail, but just know in the back of your head as a practitioner. All right. When I have a constitutional lien, I'm not as bulletproof as I would be with a statutory lien, because there's some ugly case law that a smart lawyer on the other side could file against me in a case worth several $100,000, couple $1 million, maybe even more. They could get creative to knock a lien out. It does exist, and we'll talk about it moving forward. Split of authority as to removables. Okay. Removables versus articles versus buildings. All right, article is a good or chattel, right? All right, well, then why are we talking about removables? Well, if it's a removable, if you're arguing it's part of a building, but it's actually a removable, you run into a split of authority between Dallas and Amarillo as to whether your constitutional lien applies to the removable product. Generally speaking, an improvement that can be removed without material damage to the realty. Okay, those of us who had property in law school, which is every one of us, those of us had taken it recently and might remember some of the cases we talked about an improvement that can be removed without material damage to the realty. That sounds like a fixture, doesn't it? It does. It's kind of the same type of analysis. So Dallas says that if it's a fixture, if it's removable, so basically if it's not a fixture, well, your lien issue your lien went out the window. Your constitutional lien went out the window. That's FDIC versus Bowdoin down there. Now, and then Amarillo says the opposite. And Amarillo goes so far as to say in Hurrell Sign Covey Dominion, they go so far to say not only is constitutional work, statutory works too on removables. So I don't care if it's removable. They say you get a constitutional lien. All right. And here's the fun part of these cases. I think Dallas, don't quote me on this, I think Dallas was 93 and Amarillo was the newer case in 95. Both of those, look at the end of the site, are writ denied. All right, so the Supreme Court was happy with both of those at the time they were made. The Amarillo case being newer, it makes you wonder, okay, did the Texas Supreme Court obviously didn't issue an opinion on this. Are they happy with Amarillo's discussion? Maybe, maybe not. But I don't know of any case law that has been determinative on that point.
Ben, we have a question that was asked by Richard.
Sure.
An improvement to realty or an improvement to a pre-existing improvement?
Let me think about that. An improvement to realty or an improvement to a pre-existing improvement? That would depend. Okay, I think you're getting hung up on improvement. So an improvement to a pre-existing improvement is totally okay. That's a repair. Repairs are authorized under the Constitution to provide you a lien. So a repair of a existing article or an existing building, that's fine. That works for you. It really turns on, well, according to Dallas Court of Appeals, it turns on whether the article is removable or not. So there's a point break. Not to talk about the great 80s movie, but there's a point break where you've got to figure out if this thing is basically a fixture, if it is a removable. If it is removable, Dallas says, well, there goes your constitutional lien. It walked out the door with your removable property. If it's not removable, and Amarillo says, no, you installed it in the building. It was part of the building at one point. Basically, you're good to go. I hope that answered your question, sir. Okay, more chinks in the armor. Going to talk a little bit about relation back doctrine. All right. To have in the back of your head as a practitioner, liens relate back to visible construction or delivery, which is for a materialman who deliver stuff like your wood or your screws or what have you, to the property. So if there's visible construction on the property, which if that sounds like a fact question to any litigators in the room, you are correct. Tough thing to establish. But that is the earliest point at which your lien takes hold. Okay, so now we got to look at that case I talked about a little earlier. Now we got to look at McConnell. I'm running a little bit behind time-wise, so I'm going to kind of shoot through McConnell, but I want everybody to be aware of it. McConnell, while subsequently questioned and distinguished by at least, there's way too many words on this. Just trust me, I'll walk you through this one. McConnell has been distinguished by 3 courts and actually directly refuted by a subsequent appellate report, but McConnell is a Texas Supreme Court decision from '57. It has not been expressly overruled. This language down here will tell you why that is the case. But what's critical is that McConnell said that a deed of trust, a mortgage lien, was superior to a constitutional lien. And most lawyers would bet their bottom dollar that that could not happen. But McConnell says, yes, it can, because the mortgage lien, and this is how bad the facts of this case were, the mortgage lien was actually, or the mortgage loan was actually taken out to pay for the construction work. And the mortgage company knew that at the time. But the Texas Supreme Court said that, yeah, but at the time they took out the mortgage, no visible construction on the property or no delivery on the property, such that a constitutional lien could attach. And they gave they made the mortgage lien superior to the constitutional lien. And a lot of lawyers are going, how could that be? And a lot of subsequent courts have said, or 3 at least, subsequent courts have said, how could that be? The Supreme Court's reasoning is there. It would broaden the constitutional and statutory provisions of a constitutional lien so far as to create many complications in this class of business. All right, well, let's see what's happened since. I went too far. Backing it up. All right, worthy of note, because I thought it was worthy. First Federal Savings and Loan Association versus Stewart Title Company. Texas Appeals, Beaumont, 87, writ denied. Writ denied. You would think that would be more important than it turns out it is. They say the proposition that a priority position of a mechanics and materials lien cannot be related back to pre-mortgage work for which full payment has been made is not sound. They are telling you McConnell's wrong. But deep down in that case, and if anybody ends up briefing this, you're really going to want to know this. However, the appellees conceded this point in their briefing. With the Beaumont Court of Appeals stating that the relation back doctrine is not free from doubt. Okay, so this wasn't actually a point of argument, a point of contest between these parties in this appeal. So as I read this case, the finding of the Beaumont Court of Appeals is kind of dicta, but they wanted to come out and say that, hey, this is where we think the law is. Obviously, the Supreme Court said writ denied, so the Supreme Court might think that's where the law is on this issue. But these cases, these 3 or 4 cases kind of sum up the last word on this. And I wouldn't be a bit surprised if the prevailing reasoning is that of this First Federal Savings and Loan Association case in 87, which is, if they can relate back to pre-mortgage work. All right, here we are. Here's where you get in trouble. Up to this point, we've been talking about constitutional liens. All right, if you've gotten to this point in analyzing, a lot of you may even have clients you're thinking about right now. That's what I always do, and kind of run through the numbers. If you've made it to this point and you're okay, and it's a commercial project, I think you're going to be all right. You're probably going to have a constitutional lien. It's going to be pretty bulletproof. Make sure to get something on file. Make sure to look at the timing of the pre-mortgage work or when the mortgages or any potentially superior creditor did their work or entered their deals. But generally, constitutional protection is pretty broad, and you should be okay. Here's when you're not. Homestead determination. First note, before you get this protection, you got to prove it. And the burden of proof, at least initially, is on the homeowner. I am trusting. I'm not really going to go through what a homestead is. This is one heck of an educated audience. We're all legal practitioners. We're all lawyers. Homestead protections. If we're talking about homeowners in a residential construction context, basically. So that's the only situation in which any of this now is going to apply, any of these protections. None of these protections are going to apply to your commercial projects. Okay, owner must prove property as homestead before entitlement to homestead protections. That is true. Burden's on the owner. Owner has a burden of proof. Okay, the 2 things that the question turns on. Overt acts of homestead usage. Overt acts, what you've actually done, where you actually live, where you actually work, where you actually commute to, how much time you spend in a certain house. All of those things are overt acts of homestead usage that you prove. All right. The intention to claim property as homestead. This is a lot of lawyers know this one. This is the one where it's where you intend to maintain your domicile. We hear about that in the personal jurisdiction context a lot. Well, this is not in that context, but they use the same language. The intention to claim property as a homestead. All right. Now, societally, a lot of our practitioners in my audience will know Texas is a big property rights state, and it's a bigger property rights state when they're talking about your home. Any lawyer that has done any foreclosure work, what do you know? You know that the court is going to hold you over, if not above, the requirements of the law for foreclosures. This is homestead liens are kind of the same thing. Traditionally in law, mechanics liens are very favored right up until you butt up against the other, even greater favored right in Texas, a person's home and a person's right not to lose their home because of some monetary dispute. So with the intention to claim property as homestead, you're going to find a lot of kooky cases out there. You're going to find a lot of stretch arguments for this intention that worked. I read through them, you know, occasionally when I'm doing research for my clients, and I kind of laugh to myself and go, wow, I might not have even, that as my old law school professor said, that didn't even pass the giggle test on making that argument, but they work. So make the best argument you can and stick to it. Make it. Because the courts are typically going to be on your side in this. It's not even a political issue. I've never seen a judge kind of not be in favor, at least generally speaking, of protecting somebody's home. That kind of goes without saying. So use that in your favor. All right. We talked about the initial burden. The initial burden must be met by the owner, but the burden shifts to the challenger. Aha, okay, so you got an initial burden. You say, I live there. My kids live there. I've lived there for 10 years. Judge goes, yep, sounds right. Then burden shifts to the challenger. Here's the 3 ways you get to knock it off. Abandonment, alienation, death. Abandonment, self-explanatory, kind of. Alienation, that comes up when you got 2 properties, you got 2 homes, and you summer in New York and you winter in Los Angeles. I don't have that issue, but for those of you who do, then there's a fact issue as to whether, which is your homestead, okay? You get 1 under Texas law. So, and you might have designated, you know, for various tax reasons, you see folks accidentally, completely legitimately, you know, designating in both situations, but that doesn't really matter. What it comes down to is the facts. So alienation is what you argue. You say, no, he really lives here. Here's the testimony of his gardener who says he's there all the time. Okay. Death. For anybody in my audience that's dealt with probate, what happens when your client passes away? Well, first of all, they usually already have, if you're a probate lawyer. Second of all, their property is usually not subject to the state tax homestead, at least in many counties, if not all. I'm not an expert in that area, but that's what happens. All right, and when that happens, you also lose the homestead protection, or you can, if it's a single property owner, individual property owner, use the homestead protection. If there are other people there who can claim homestead, you're in a much more complicated situation. And that's actually probably true the majority of the time. So status determined as of date. Okay, this is important. Status determined as of date of construction agreement. That's the status as a homestead. Determined as date of construction agreement. All right, we're going to talk about the McKee case here a little bit. This is out of Waco, 2005. No petition, so not super duper binding, I guess. Still good law when I shepherdized it. McKee says basically, the facts of McKee are a homeowner was living in his home, contracted to build a new home on an empty lot. And they wanted to use their homestead defenses for the new lot. The court said, no, you don't get homestead defenses on the new lot because at the time of entering the construction agreement, which was oral, by the way, in this case, at the time of entering that agreement, nothing was built and your homestead was where you already were living. That would have been a fact determinative analysis because, of course, you get to argue intent, but it's a kind of tough road to hoe if you're living in the house that is currently your homestead. There's legal arguments to be made on either side, but Waco said, nope, you don't get your homestead defenses. This was just like building a non-residential commercial property for the purposes of this lien, and he gets his constitutional lien. So if you do have a new construction case, even on a homestead, no McKee, because it is a loophole that could be critical for you. Okay, Section 50A protections. This is Section 50A of Article 16 of the Constitution. So this is constitutional protections dealing with homestead liens. There are additional protections. There are additional hoops you have to jump for homestead liens against, or for liens against homestead residences. We're getting into the real meat and potatoes of this presentation. This is the critical stuff. All right. Here are, I call them potholes. They're worse than that. They're like bear traps, really. Okay. All right. All right, everybody take a screenshot, print this one out, redline it, highlight it, stick it on your wall. This is if you watched up until now, this is why you did it. Section 50A, protections. This is in the Constitution, applies to constitutional liens, 100%. All right, here we go. This is the one that everybody knows. You got to have a written contract. Okay, a significantly smaller percentage of folks know that both spouses have to sign the written contract. That has knocked out more purported constitutional liens in my practice than almost any other issue. They just didn't get the spouse to sign the written contract, and all they were going for was a constitutional lien. All right, that's ugly. Contract cannot be executed before the 5th day after owner applies for credit to fund the work of materials. Many of you who are familiar with DTPA law, that kind of thing, you'll see this type of language: 5th day, 3rd day, 10 days, they can back out, right? Well, the Constitution, man, it's got it built in. Now, oh no, I'm reading the wrong line. Okay, everything I just said was in relation truly to 3 little I down there. Contract must be rescindable up to 3 days after execution. The 2 little I, that's never come up with me. Maybe it's come up with others in practice. I've just never dealt with that particular issue before, never had to raise that particular defense. Yeah, 3 little I, contract must be rescindable. Must be rescindable up to 3 days after execution. Here's a question. I haven't researched this, but here's a question to ask yourself, and maybe research on this issue if it comes up for you. Contract must be rescindable up to 3 days. Does that mean the contract has to state it's rescindable up to 3 days? Or does that mean the contract, as a matter of law, based on the Constitution, is rescindable up to 3 days after execution? I think it's the first one. I think it has to say it in there. Otherwise, you got a pretty good defense. But I don't know if there's a case on that or not. I really don't. All right. Here's the doozy. You've waited 43 minutes to hear it. Here it is. Contract must be executed by the owner and spouse only at the office of a third-party lender, an attorney, or a title company. Third-party lender, an attorney, or a title company. Man, this is never the case. The only time I've seen this, the most common I've seen this occur is actually lender, the bank. I have seen contracts be executed at the bank, just everybody sat down there and did it there, mostly because the general contractor used the offices of the bank, because in residential contracting, a lot of times the general contractor doesn't have a formal office or doesn't have an office that is nicer than a bank because, of course, the bank's got the money and their offices are nice. An attorney, man, you never see that. Title company, that's probably the second most common. But man, a contract must be executed by the owner and spouse only. That is straight out of the Constitution at the office of these 3 folks. Rare. It's just rare. It's a lot of I dotting and T crossing that doesn't usually occur with residential stuff. All right. There you go. That's the critical part. Hope y'all enjoyed it. Now I'm going to tell you a bunch of other stuff, but know that, please. All right. Expedited lien removal procedure.
Ben?
Yes, sir.
Real quick before you jump, Cynthia has a question, so we want to make sure to get to all our questions, and we'll save an extra few minutes at the end if there's any questions. Cynthia says, thanks for the presentation. I had a constitutional lien filed on a homestead, and I filed a motion to remove the lien.
Yep.
The judge did not believe that the contract had to be executed in those offices. The judge refused to remove the lien, and then we were awarded attorney's fees at the end of trial.
Let me see if I understand that correctly. The judge said, so I read that to say attorney's fees were rewarded against you. I guess that would make sense. But at the end of so I don't know of any legal basis why the judge ruled that way. I do know that this stuff, these types of defense, I mean, it's in the Constitution. If there's some law out there or some case out there that says that these don't apply.
If Cynthia wants to add a little more detail, we can
Please.
circle back on that. And maybe this was an appellate issue that was overturned.
Cynthia, file your appeal. You're going to make some great law here because this is, these are constitutional lien protection. If your guy or gal had a statutory lien, they might have a better argument for these not to apply. Because these are in the Constitution, and I actually have a slide moving forward that's going to talk about statutory protections. Actually, I think it might be this slide or the next one. And so the Texas Constitution has the 50A protections. The Texas Property Code by the legislature has ones that apply to statutory claims. I don't know the facts of your case, but I am suspicious of that ruling by the judge. So I think you at least have a very, very, very solid basis for appeal, I would think. But let's hop into that issue since we're on it. All right. How am I doing on time? Ooh, 13 minutes. I'm gonna have to run screaming with my hair on fire. All right. So this is the expedited lien removal procedure. I'm going to fly through this. Many of you might know it. You can read the rules straight out of the Texas Property Code 53160. It allows for removal of lien, but it's not a final judgment on the lien. This is the procedure you use. It's like a summary judgment. You file it first thing. You raise your homestead defense. You prove your homestead defense. That allows you to try to knock out the lien, but it doesn't knock out the lien permanently. It just knocks out the lien it's like getting a TRO on the lien. It knocks out the lien until at the end of the trial, you get a final determination by the judge on the lien. So for that period, there is no lien on your property. You can do whatever you want with your property. Now there's lis pendens, there's litigation about the property. So it's still, is title clear? Nah. If I'm a title insurance company, of course I'd say it's not. So you might even still want to bond around the lien, which if you're capable of doing it, in my legal opinion, is probably preferred to this, or at least should be done in conjunction with this, to bond around the lien just to clear title in case you want to sell the property, which is still an option. Grounds for removal. Okay, so here's the deal with this 53160. It only applies to this kind of goes to Cynthia's issue. 53160. I don't know, Cynthia, if you use this procedure. This procedure is way more limited than your usual homestead defenses. So let me share my screen here and show you what I'm talking about. All right, 53160. Here's the deal. It's limited to these as far as homestead property defenses. No contract executed or filed is required by 53254. This is not 50A. This is Texas Property Code 53254. This is the section that puts where the statute puts its own requirements on statutory liens. Affidavit claiming lien filed to contain 53254 notice. So there's specific language that's supposed to be in these affidavits that has to be in there. Notice of claim has to have very similar language. So these are the issues they'll let you bring up first thing. So the court basically wants to know if you didn't get the warnings you were supposed to get as a homeowner, or there was no written contract. If those three issues come up, man, file your section 53160 motion and just nail them with it. And you should, I'm sorry, Cynthia, if you got one of these going for you. Now I could say, so the 50A protections aren't listed here, right? So if you file a 53160, you might be denied on that basis. You might need to file a traditional summary judgment to bring up your other homestead defenses, like the ones that are under the Constitution, under 50A. But man, they're real. You better bet you. Okay, I've told you about that. All right. No interlocutory appeal on this. Motion can be heard at 21 days notice. We're claiming. So this is stuff you can kind of read, procedural stuff. Here's the critical part. Here's the whole reason for this slide. Live testimony is allowed. Okay. It's not like a summary judgment where you can't have live testimony. You can bring your homeowner and he or she can talk about, or both, can talk about why it's their homestead. And I think, I always prefer live testimony over anything written. So do it if you can. It makes it a little bit like a mini trial in that regard. Remember your homestead burden, because you got to meet your homestead burden before you get the homestead protections. Why not file a traditional MSJ? This procedure provides an opportunity to clear your title immediately. And then on this next, went too far. So that's really the only benefit that I can discern is, regardless of continuing litigation, this isn't subject to an appeal. You can get the lien knocked off. It would prevent you from needing to have the time or expense or tie up your collateral in a bond around bond or a surety situation to clear title to your home momentarily or for the time being. All right. Removal of a lien may be stayed. Okay, so this is irritating to me. So you go through all that process, 53-160, and the judge agrees with you. The judge says, all right, lien's off the property for the time being. Well, if the contractor files a bond, the lien's back. But they got to be really sure, because the lien has to, the bond has to cover attorney's fees and costs as well. So why bother? If the lien is removed, the property is then sold, the lien is then reinstated. So, all right, I'm slow down a little bit because this gets timeline-wise a little confusing. If the lien is removed, the property is then sold. The lien is then reinstated. Lien does not relate back to the original date of attachment filing. So for the purposes of creditors, the situation where we talked about mortgage holders, it doesn't relate back like a usual construction lien would anyway. In other words, you can cut through the ability of the lien to relate back, which might, a smart practitioner on the other end, if he gets his lien cut, he knows, oh, now my lien's behind however many other liens. This fell from a very powerful lien to maybe not so great of a lien, and maybe not worth all of our time and effort and expenditure on the case. It can be, for a smart practitioner on the other side, it can be really demotivating, I would think. All right, fraudulently filed liens. I think this is pretty important. Factually incorrect. Okay, whenever I see a lien that's filed, a lot of the times I think to myself in my lawyer brain, this lien should not have been filed by a lawyer. The lawyer should know this is not an enforceable lien, either under the statute or under the Constitution for homestead purposes. This lien, as it was filed, when it was filed, loses. So I always think, okay, well then, early on, before I had really done some homework and done some litigation very, very early in my practice out of law school, maybe, I had thought, okay, well, hey, I got a really good argument for fraudulent lien in that instance. Not so much. There's a distinction, and here's the case. I've given you the site, between an affidavit that is factually inaccurate in some respect and one that is attempting to perpetrate a fraud. You can be wrong. You can make a mistake in filing a lien. The key with fraud, as this case will tell you, and any case about fraud will tell you, is intent. All fours, right? From law school. Intent is what's critical. So, in a lot of situations, if you get somebody up on the stand and you say, hey, did you think you had a valid lien when you filed this? And the contractor goes, yes, of course I did. Oh, well, you're pretty much done in the fraudulent lien department. I have seen email correspondence going back where office managers will say, hey, I think we're late on this, or I don't think we have a valid lien for this, that, or the other reason. And whoever is in charge will say, I don't care, file it. Okay, that's good stuff. That's good stuff for intent to file a fraudulent lien. I've seen liens filed after the project was completely abandoned, even before any non-payment issues. They literally walked off the site and then filed a lien for not being paid for the work they didn't do. Like stuff like that brings up this fraudulent lien issue. And then they went around and filed a lien. So there you go. Like I always tell my clients, anybody can file a lien. All you got to do is sign your name and swear to it. But it's kind of an extrajudicial process. You just take it to the property office and file it. So if I prove knowledge and intent, as to the fraudulent lien. What do I win? You win a minimum of $10,000 in economic damages, court costs, attorney's fees, exemplary damages, my favorite two words, and an amount to be determined by the court. So this is great language for letters saying, get rid of your lien before I come after you with a pitchfork, because you're going to lose. And when you lose, you're going to lose bad. And that's the purpose of this. And in certain circumstances, like when I talked when they abandoned the project, you just know the lien is fraudulent. And you know the facts are going to bear that out. Man, it's great ammunition it's great to tell your client to say, look, if you have of course a defendant that is has any money, liquid at all, a worthy target, this is really good. This rule provides you a Texas Civil Practice and Remedy Code 12 provides you a great weapon. Okay, risk of attorney's fees award. Most of us know this one, so sorry. Section 53-156 provides for recovered attorney's fees. All right, to declare that any lien is invalid or unenforceable in whole or in part. All right, so you get your attorney's fees. It's a mandatory statute. All right, but here's the really great part if you're a homeowner, and the not so great part if you're trying to enforce a homestead lien. Here's the magic. The court has discretion to spare a residential owner from attorney's fees under this otherwise mandatory section. This goes back to Cynthia's question. So the court ordered attorney's fees. I would be arguing from the top of my hill, Lion King up there holding Simba saying, man, if there's any situation in which, don't I get to defend my property? And now you're telling me because I tried to use the language of the Texas Constitution to protect myself, my home from this claim, not myself, my home from this claim. Can I get some help in attorney's fees? And the law actually allows the court discretion to deal with that. So Cynthia, man, that's two knocks on that decision that I kind of vehemently disagree with, frankly. I'm sorry that was the result. Takeaway. There is less risk in combating a potentially improper lien as homeowner than there is a commercial property owner. That is the truth. There is less risk because of this discretionary language and because of the just slew of defenses that homesteads have. 2 minutes left to go. I ran long. I'm sorry. That is the end of my presentation. Thank you very much for your kind attention. I'm Ben House. Thank you.
Ben, thank you so much. And Cynthia came back and cleared it up a little bit. She said at the end, oh, screen's moving on me. At the end of trial, the judge made a final determination to remove the lien, and he awarded our client's attorney fees. As for section 53-254, the contractor filed the contract in the lien property records after he filed the lien.
There you go.
The contractor was awarded damages by the jury, but the judge did not award attorney's fees in the final judgment. We were awarded attorney fees.
Okay, so 53-254. So the judge used the statutory rules, the statutory homestead protection rules instead of the constitutional rules, and came to the right conclusion, which is great. So the system works. Yay.
Yeah, they don't always do that.
I ain't saying nothing.
Well, Ben, I just wanted to thank you. And again, Ben House in the Houston area focuses his practice on construction. It's a great, I have a lawyer audience today. So if you need to reach Ben and you're in a different part of the state or a different part of the country, this is a great way to facilitate business between other lawyers and network. Again, I'm Seth Bloom, Senior Director of Attorney Services at Level Set. And check out Level Set. If you're not if you don't have a claim profile, please email us, please contact us, and we'll get you one. We'd love to see your participation. This is our first CLE in Texas, and we hope to do more. We've done one in Florida, and I think the next, we're going out west to California for October. So we'd love to get everyone involved in here to participate in webinars, CLEs, post blogs, and become part of our team. I know most of you that are participating today are already in that. And Ben, I just want to thank you again. Any other questions we'll address directly to you. And thank you for enjoying this. And we're going to hope to provide more learning and free CLEs in the future. Thank you, Ben.
All right. Thank you. Thank you, everybody who, I hope some of these slides were pretty useful. That those defenses can make a huge difference. Thank you, everyone.